And we are live. It is Thursday, January 18th, 2024. I'm joining you here from the Mar-a-Lago bathroom. Quinta is joining from
the Brookings
an
Institution.
undisclosed location at the Brookings Institution. And Roger Parloff is back from the Jura in Washington, D.C., where he is no longer a maquisard. Anna Bauer may or may not be joining us later. She is stuck in court, being the court rat that she is. So we are going to either hear from her or not later. We've got a lot to talk about. So let's start with Section 3 of the 14th Amendment, because, it's all anyone's talking about these days. Roger, we have briefs due today. Have any of them been filed? Has anybody had anything to say?
I don't think we have Trump's brief yet. We have a lot of amicus briefs. The briefs that are due, the amicus briefs are due, are the ones that are either supporting Trump or are supporting neither party, which means they're clarifying some point of law. The ones that are supporting the voter challengers will come in another, I think, January 31st. Does anyone know that I'm wrong? January 31st, yes. And then the replies will be February 5th, and then the argument is February 8th.
And it occurred to me this morning when I was talking to Charlie Sykes on the Bulwark podcast that if I were the Supreme Court, I would really want to hear from the Solicitor General on this. Have they asked for the views of the Solicitor General, and are we expecting an SG's office brief?
I have not seen a request like that on the docket. The docket I have is not always complete. Have you seen anything like that, Quinta?
I have not, for what it's worth, nor have I seen any conversation around that. I know Jack Goldsmith speculated on Twitter about whether or not Special Counsel Jack Smith would want to weigh in. I haven't seen any indication of that either. It's not clear to me why. If I were Smith, I would want to stay as far away from this as possible. No. Yeah, exactly.
It's true. Although if I were the Solicitor General, this is a matter that obviously affects the executive branch very deeply. And it would seem like the Solicitor General might well have things to say on the subject.
Oh, the Solicitor General. Yes, I thought you said Special Counsel, though.
I certainly meant the Solicitor General.
Okay.
But there's no indication of a request for the views of the SG.
No.
All right.
I have everyone else's views.
Yeah. So I think it would be odd for the SG not to weigh in on a matter that bears on who gets to be president and what the meaning of a core provision of the 14th Amendment is. All right. So let us start with the DC Circuit, which we have heard nothing from.
We might want to mention while we're on Section 3 that we got a ruling from Maine yesterday.
Oh, yes. So tell us about Maine.
Yeah, they have a fast track system there. You remember the Secretary of State, they have an administrative proceeding that begins before her, and she had determined that after a hearing that Trump was disqualified. She followed the reasoning a lot of the Colorado court. And so by yesterday, a superior court, appeal to a superior court, the Superior Court had to rule by state law, and Justice Michaela Murphy of Kennebec County, they call their Superior Court judges justices, She remanded to the Secretary of State with instructions to reconsider after the Supreme Court rules. Basically, she wanted to just stay the case herself and wait till the court ruled, but she felt Maine law didn't permit that, but it permitted her to do this. She did not vacate the ruling, so the ruling sort of still exists out there, the disqualification by Bellows is her name. I think Jenna Bellows, but it's apparently stayed. Now, under Maine law, this was supposed to then go to their Supreme Court by January 31st. And they were then supposed to rule. I assume, I don't know if the voter challengers are going to try to appeal the remand ruling to the Supreme Court. I sort of doubt it. I think we're beginning to get what looks like a little bit of consensus that people are going to wait until the Supreme Court weighs in.
I mean,
and that's what the Oregon Supreme Court also did.
Yeah, so I would think that the posture of Maine now is about as clear as it is going to be, which is pending the Supreme Court, which is if the Supreme Court affirms Colorado, he will be off the ballot in Maine as well. And if
I mean, it doesn't say that.
No, but it says, I mean, if you combine the Secretary of State's judgment with an affirmance in Colorado, it would be very hard for the Maine court system to say no, but that logic doesn't work here. But then, but there's no point in trying to preempt the Supreme Court on this. So it sort of goes into abeyance until we hear from 5 justices. It seems to me to make a lot of sense, although it does seem to defy the statutory deadlines in Maine law.
That's right. But she said, there's all these federal constitutional questions of first impression, and it would be imprudent for her to weigh in when we're likely to get some sort of definitive answer to some of those questions.
So, all right. Any other Section 3 action?
Yeah, I mean, theoretically, there's this administrative proceeding in Massachusetts. We're supposed to get a ruling on January 29th. There's an administrative proceeding in Illinois. We're supposed to get a ruling on January 30th. I'm sure there are others out there. Those are the ones that I know have seemingly firm deadlines. I don't know if those are stayable or not in light of the SCOTUS rule.
So is your impression that they will all just back up waiting for the Supreme Court, or do you think some of them are going to be like, well, we've got to decide this, and the Supreme Court will do whatever it does, but in the meantime, we're going to keep him on the ballot or throw him off the ballot, or how is it likely to work procedurally?
I think if they have the wiggle room to stay it until the Supreme Court rules, that's what they'll do. Some may feel that they just don't have that wiggle room under state law. In addition, just imagine, if I assigned you the problem of write a ruling on this question, which has umpteen parts to it, and do it by January 31st, wouldn't you rather say, let's hear from the court first?
Right. Let's see how much work we can get the Supreme Court, how much of my work we can get the U.S. Supreme Court to do.
Because this might vanish after that.
Right.
I say this is consistent with my hot potato theory of Trump, which is that every institution that has the chance to deal with him desperately wants to fob the issue off on everyone else. And here, I think various state officials and courts have an extremely good reason to just kick it to the Supremes and see what they do.
Well, especially because the Supreme Court is actually the controlling authority. And so
No, it's a very good reason,
it's a
right?
good
I think
reason.
that sometimes people toss the hot potato with very little reason, but here I mean, it is literally their job to decide this.
All right. So, speaking of courts who it is literally their job to decide things, it is literally the job of the DC Circuit Court of Appeals to have already decided, because we said by the end of the week last week, and we said 48 hours. I think I personally said 48 hours. And the DC Circuit has no business proving us wrong. But it seems to have. So, Roger, Quinta, what do we know about what's going on?
Oh, we know nothing, but that won't stop us. It never has. So my theory is that Judge Karen LaCraft Henderson is writing a long and irrelevant and baffling concurrence, and that's holding things up. But
Quinta LaCraft Jurecic, do you have a theory?
I think that's as good a guess as any. I think I also predicted 48 hours, so I will also eat my crow. But yes, I mean, look, we don't know. They've been quiet. We'll find out.
All right. There is a subject, however, about which the DC Circuit has not been quiet. Speaking of baffling quasi-concurrences. And it involves executive privilege. I confess I had a little bit of a hard time making head or tail of this matter that involves Twitter, Trump, and lower court Judge Beryl Howell, who was chief judge at the time. Quinta, what do we know?
So this is a little bit of a strange one. So I will open just by explaining what specifically we're talking about, and then I'm going to rewind because it, as you just hinted, Ben, requires a fair amount of context. So what we got was a ruling from the DC Circuit on January 16th that was a denial of Twitter's petition for rehearing en banc of a ruling that came down from a panel of the DC Circuit over the summer concerning a appeal, again, by Twitter of a contempt order from the district court, in this case from Judge Beryl Howell, then acting as chief judge. We're talking about, so a denial from a petition for rehearing en banc at the DC Circuit is nothing new. The DC Circuit does not like to rehear things en banc. But this particular one is interesting because there is not a dissent from the denial of rehearing, not a concurrence from the denial of rehearing, but a statement, which is something that I have never seen before. From the three Trump appointees on the court, Judge Naomi Rao, Greg Katsas, and Justin Walker, along with one Judge Karen LaCraft Henderson. This statement is written by Judge Rao, sort of objecting maybe to how the courts have handled what they believe is an executive privilege issue that has to do with this case. So now that I've said that out, let me back up and sort of record scratch, freeze frame, move backward in time, and then I'll explain what this is about and why it may or may not matter. So all this traces back to some litigation that listeners may recall from over last spring and summer that has to do with a warrant sent by special counsel Jack Smith to Twitter, then under the control of Elon Musk, which is relevant, for material relating to Trump's Twitter account in the course of the January 6th investigation. Twitter resisted handing over that information. It seems like there was perhaps some confusion in terms of communication between the government and Twitter over it, which I think probably traces back to the fact that Twitter's legal department was pretty substantially hollowed out after Musk's takeover. All of this back and forth resulted in a court hearing in February. So sorry, I've gotten the timing a little wrong, but last winter, a court hearing where the Twitter and the special counsel hashed out before Judge Howell Twitter's objections to this warrant. Twitter agreed to hand over some material, then it failed to hand over the material by the deadline that Judge Howell had set. And because she had also gotten both parties to agree to a structure of fines for noncompliance that increased geometrically, Twitter's delay in handing over that material ended up landing them with a fine of $3,500,000. So all of that is the background. The appeal has to do with, so Twitter was essentially appealing this contempt fine along with some other aspects of how Judge Howell handled the case. The DC Circuit dealt with that over the summer. And now we have this appeal for rehearing en banc that was denied. What does any of this have to do with executive privilege, and why are we talking about it? Great question. So one of Twitter's arguments before Judge Howell initially was that they didn't want to hand over the material because they could see that there were DMs in the account, direct messages in the account, that had been sent either to or from President Trump. And that they believed that there might be executive privilege interests in those DMs, given that he was president when they were sent or received. They hadn't looked at them. They're just sort of, the data is such that they know that they exist. We have no information about what may be in them. Judge Howell, we now know because of a transcript of the proceedings that was unsealed, was not particularly impressed by this. Didn't take it particularly seriously and ruled that Twitter had to hand over the materials anyway. This gets us to the situation with the fine. When Twitter appealed Judge Howell's ruling on contempt and other sort of procedural matters, the DC Circuit, the panel, in a ruling by Judge Florence Pan, whose name may be familiar by now, didn't really address the executive privilege issue. It comes up, but it's kind of nested within another issue, which is that Twitter is arguing that it has a First Amendment right to be able to disclose to President Trump that this information is being sought, given that one of the measures that Judge Howell implemented was a non-disclosure order, essentially to prevent the investigation from being interfered with. So the DC Circuit in Judge Pan's ruling essentially upholds everything that Howell does not touch substantively this executive privilege issue because it's focused on the sort of broader First Amendment question of whether Twitter has a First Amendment right, and it says it does not. This brings us then to the denial for the petition for rehearing en banc. And the statement by Judge Rao. So essentially, Rao is zeroing in on this kind of subsidiary argument that has been made by Twitter throughout about whether there is potential for executive privilege implications of handing over these DMs that were in Trump's account. And what she argues is essentially is not necessarily that Trump should have triumphed in invoking the privilege, but that he should have been given an opportunity to invoke it before this material was handed over. There are some weird aspects to this. So for example, we know from previous court filings that the material that Twitter eventually did hand over included 32 direct messages. Judge Rao refers to these as messages from Trump, so messages sent by Trump. With apologies to Judge Rao, I don't see how that can be right. There is no indication elsewhere in any of the reporting or any of the other court filings that these were messages sent by Trump. And because she's saying all of those, we know there are only 32 messages. She says all of those 32 were from him. So in her version of events, Trump is only sending DMs. He's not receiving anything. That just strikes me as a bit odd. And I think it
Not really the way people use DMs.
Exactly. And I think that kind of inflects her understanding of the potential privilege implications, because I looked at what Special Counsel Smith had said about the 32 DMs and thought, these could be anyone, right? It could be spam. We don't even know if Trump read them. So all of this, it's very odd. I've been talking for a while. We can talk more about how it is that the president even could have a privilege in communication sent on a public platform. It's a bit fuzzy, but that's essentially what Judge Rao and her three colleagues are saying.
And just to be clear, it is not fashioned as a dissent.
No, it is a statement.
It is not fashioned as a concurrence.
Correct.
Is it clear how the four of them voted on the question before them, which was whether to grant rehearing en banc?
No. we just have that they have this statement. And it's not really obvious what is going on here.
Quinta, is one of the issues that Trump himself, even when he became aware of this situation, never asserted executive privilege?
So that's correct. So that's part of what's strange about all of this, is that partly what we know is that there's an initial decision on the part of Judge Howell to not disclose the fact that this information is being sought. And Judge Rao seems to think that there should have been some process by which to kind of flag to Trump or perhaps his representative or something along those lines to kind of give him an opportunity to weigh in. That said, even after this information did become public that all this had happened, at no point did Trump seek to intervene.
So I would read it as I don't know. So like, I would say when the court does something per curiam, which means as the court,
and this is a per curiam ruling, to be clear,
and you don't dissent, then you are presumptively represented by the per curiam. And so I guess the question that puzzled me about this is, if we are to assume they are not dissenting, because it is not crafted as a dissent, and they are therefore represented by the per curiam, why is it not a concurrence? Which I don't
have an answer for you.
It's it's just strangely postured, and some of the people involved in it are very eccentric, but some of them, like Judge Katsas, are not very conservative, but a quite normal judge's judge kind of guy. So I'm a little bit just befuddled by how to read it. Roger, do you have thoughts?
I don't really. You have. I'm just puzzled by it.
All right. We will leave ourselves in a state of puzzlement on this matter and move to the next puzzling feature and creature, which is Judge Eileen Cannon, who has done a few puzzling things and been asked to do a few more. Roger, why don't you bring us up to speed on the antics in South Florida?
Yeah, a number of things have been going on. We're still laboring over this SEPA Section 4 stage.
And remind us what that is.
Yeah. So after initially the government was willing to provide about 5,500 pages of classified, not provide, but to make available. They don't turn over the classified information, but make available 5,500 pages. That was mainly the documents in the 32 counts that Trump is charged with for willfully withholding. They were going to make that available to Trump and to the lawyers for Nauta and De Oliveira. And there were objections of different kinds. And then she, on her own, Judge Cannon, decided that she couldn't even say yes at that stage. She had to wait until Section 4, the Section 4 stage. The Section 4 stage is when after the government has conceded that certain things should be made available, it wants to make some additional discovery available, but those documents only in part, because there's ultra sensitive stuff that nobody needs to know. So they want it to be redacted, or they want substitutions. They want the defendants to be told summaries of what's involved. And normally that stage proceeds ex parte. That is, the government tells the judge in a sealed proceeding with only the government present what it wants to do. And then at the same time, the defendant tells the judge, likewise in a sealed ex parte proceeding, what its defenses are. And then the judge tries to make a judgment about whether these redactions will be fair, given what the defenses are. And now, for some perspective, originally, Judge Cannon wanted the government's motion, SEPA Section 4 motion, to be filed on October 10th, and it wanted Trump's reply to be filed the same day, October 10th. They're two ex parte motions, why not? And then a week later, she would hold a hearing if necessary, October 17th. Instead, nothing has gotten decided today, still. And she made a ruling, and the reason is Trump wants to have an adversarial proceeding. They want to see, in certain ways, the SEPA Section 4 motion and want to be able to contribute and argue about it. They don't say that, they don't say Trump gets to see the motion, but Trump's cleared counsel get to see the motion. Things like this. That's been fully briefed. Incidentally, the same thing was argued in Chutkan's case, and she said, nope, the statute says ex parte, that's it. She said, she ruled recently that she wanted an ex parte hearing January 31st to discuss this with the government. And she's still postponing deciding and she's going to put off deciding whether this will be an adversary proceeding, whether the Trump will get to see any of SEPA Section 4 until a 2-day hearing scheduled in February 12th and 13th. Meanwhile, she had Trump file his objections to Section SEPA 4, which he did yesterday. And I don't know how he filed objections without seeing the motion. And but that was done under seal, and it puzzled Judge Cannon, who then issued an order saying, "Did you really mean it's under seal, but it's not ex parte? Did you really mean that it's not ex parte?" And Trump said, "Yes, it's not ex parte because we still haven't told you yet what our defenses are. We want to set up a meeting, ex parte meeting later to tell you what our defenses are." Anyway, the thing is limping along at very slowly. We won't even have a decision on whether this is ex parte or adversarial until sometime after February 12th and February 13th. So that's where that stands.
And then wasn't there also, there's a Trump motion to compel all kinds of discovery?
Yes.
What's the story with that? That's
an important thing that happened 2 days ago. It's sort of like the DC case again. He wants to define the prosecution team very, very broadly, so that an enormous amount of additional discovery has to be turned over. He wants and again, Chutkan rejected this very quickly, but we'll have to see how Judge Cannon sees it. Members of the prosecution team, as Trump sees it, include the National Archives and Records Administration.
That famous prosecutorial office.
The CIA, the Defense Department, the National Security Agency, the National Geospatial Intelligence Agency, the National Reconnaissance Office, the Department of Energy, the State Department, in the White House, the National Security Council, the White House Counsel's Office, the White House Office of Records Management, in the DOJ, the Office of Legal Counsel, Office of Attorney General, Office of Deputy Attorney General, National Security Division, and the U.S. Attorney's Office for the Southern District of Florida, the Special Counsel's Office pertaining to the D.C. case, the Secret Service, the Department of Energy. So there's a lot there. In addition, to give the categories of information they're looking for, they want and almost all of this relates to theories that there is political bias everywhere. Political bias in NARA, that the Biden administration has been has been colluding with all of these agencies against Trump, and so any communications with members, relatives, or associates of the Biden administration, communications between members of the Biden administration and the Fulton County District Attorney's Office, including particularly records relating to meetings involving Nathan Wade, who is now mentioned at least 3 or 4 times in the motion. Nathan Wade is now a pressure point, and he is going to use that. Evidence relating to analytic bias harbored by the Intelligence Committee, and so on and so forth. There's also, he wants to explore political bias at the intelligence community going back to the 2019 whistleblower complaint relating to his call to Volodymyr Zelensky. He thinks that's relevant to this case. He wants to go into misuse of the DC grand jury, forcing Evan Corcoran, his attorney, to testify. Also, there's a lot of this motion is redacted, and so I can't tell exactly what portions of it are about, but some of it has to do with the way Stanley Woodward was treated before the DC grand jury. He also wants to have this motion entirely unredacted. So it's clear that, there's a lot of
public communications is a big
Yeah,
part
yeah,
of the
yeah.
purpose here. But let me ask you, one of the things that I couldn't tell, and I haven't read the motion, only the press accounts about it, but one of the things I was curious about is whether the purpose here is actually to create a defense based on some wide Biden administration conspiracy that dates back to the dawn of time in 2019 to, deep state Biden to frame Trump, or whether the goal is here simply to give her an opportunity to order a kind of impossible discovery against a wide range of agencies that, maybe it'll turn something up that is like, Hillary Clinton's email server, or maybe it won't. But what it'll certainly do is it'll turn the agencies in knots and to eat up a lot of time and thereby raise the cost to the executive branch of litigating the case. Is this a either one or the other, or is it both kind of thing?
I think it is both. It's definitely it would run out the clock if if Trump is going to it's delay. There's also an investigate the investigators strategy, a sort of a Durham investigation sort of thing, which will benefit both his campaign and possibly his defense if he's allowed to bring in, to make this claim that that this is all about the Biden administration trying to keep him from becoming president, keep him. I think it's all of those things, and I think it's all of those things.
So unlike a SEPA ruling by her that's really crazy, there's no obvious interlocutory appeal if she orders some sort of deranged discovery along these lines. I suppose they could try to mandamus her, or they could try to comply, right?
I think that's right. Mandamus is, of course, very difficult, so it would have to be really outrageous, and but it could be outrageous. So we'll have to see.
I gotta say, I think it's a smart move for the Trump lawyers. It gives her an opportunity to be very helpful in a fashion that's paralytic vis-a-vis the government. It's good public communications that plays well on Fox News and allows them to, it's sort of consistent with their campaign themes. And who knows, maybe you get some discovery that's actually interesting.
Yeah, it's a very worrisome motion from the perspective of those who would like to see this tried in our lifetimes.
All right. Speaking of Nathan Wade, and I may take some of this myself. Do either of you, so we are down one Anna Bauer, which is to say our major Fulton County expertise, but I think between the three of us we can handle this. So Fani Willis over the weekend responded sort of to the motion about her supposed conflict of interest. She took to the pulpit of her church and announced, I don't think I'm mischaracterizing this, that while she was certainly flawed, people were out to get her. Is that a fair characterization, Quinta?
Apologies. I have not been following this thread of the Trump investigation,
okay.
so I really can't speak to that.
She also, her office also made clear that they would be filing a response to the motion concerning Mr. Wade, but not until February 2nd, which seems like a terribly long time to take to respond to a motion that raises a question of your office's integrity um, uh, and yes, and as somebody pointed out in the as Joyce points out in the chat, attributed at least some of the of the action allegations to racism. So I think we can begin now to address, at least in very tentative terms, some of these allegations. If not, we don't have a clear statement of her position regarding what is true, but she rather conspicuously didn't deny the entire gravamen of the thing. And so, Roger, what do you make of it? Is there anything responsible that we can say at this point?
I think so. First, just a little more information. Today, Judge Scott McAfee ordered a hearing on this question February 15th at 9:30. And he said that Willis must reply by February 2nd. That date is important because on January 31st, there is a hearing in Nathan Wade's divorce case over whether to unseal it. So it might well be that Fani Willis, this is speculation, may have wanted to see what was being released before filing the motion. This motion was filed back on January 8th. It's by Mike Roman's attorney, Ashley Merchant. And I guess Anna described it last week. Also, incidentally, if you want to hear that what Fani Willis said at the church, Anna did a nice little thread about the gist of it on her Twitter and Thread feeds, where I think her handle is at Anna Bauer for both, I think. But the gist of it is, Nathan Wade was hired as a special prosecutor according to the motion. His first contract was signed November 1st of 2021. And on November 2nd, 2021, the next day, he filed for divorce. And the gravamen of the complaint is that they are having a romantic personal relationship. And it implies, it's a 39-page motion, and then there's about 100 pages of documentation from Open Records Act stuff. But Ashley Merchant, the lawyer, says that part of what her motion is based on this sealed divorce file, which she was allowed to see before she realized it was sealed. So those records are not available. So we don't know if there is a personal romantic relationship. That's sort of only a tiny aspect of this. The accusation is that he's being paid very well, Nathan Wade, that he's, I think, $250 an hour, and that effectively he's making more than most of the regular prosecutors in the office. There are two other special prosecutors appointed by Fani, and I don't know how they're being paid. But because of their relationship, the claim is that she is benefiting from some of that money, in effect, because they're a couple. It makes allegations that they've traveled together to Napa Valley, California, to Florida, to the Caribbean. It alleges without proof at this stage that he bought tickets for them to go on the Norwegian and Caribbean cruise lines. So the idea is, why would this matter? And I think the theory, a couple of theories of why this would matter. You want an impartial prosecutor with no stake in the case. And in this case, we have 19 defendants, some of which are fairly minor. If you are directing public funds to your boyfriend and sharing the benefits of that, there might be an incentive to have more defendants than necessary and to keep them in the case longer than necessary. I think that would be the theory of how it could impact the case. There are probably others. She also claims that he wasn't appointed in the correct way, that Fani has to get permission from Fulton County in a way that she didn't. I think it implies that he needs to get approval from the Board of Commissioners. There's already been some pushback from that. The New York Times quoted a Republican prosecutor in Georgia, I think the head of the prosecutors organization, who was saying he didn't think that was necessary. So that's an issue. We'll have to see how that develops, if she needed any sort of approval that she didn't get. And then, of course, what she's asking for, or Mike Roman's attorney, Ashley Merchant, is asking for, is dismissal of the case. I don't understand how that would be possible. She's also asking, however, to disqualify Fani, to disqualify Nathan Wade, and to disqualify the whole office. Those are possibilities if her premises, if all of her premises turn out to be true. And as you've pointed out, there's no reply yet. We don't even know that a romantic relationship exists. We don't know that any money came back to benefit Fani. And I guess the last thing before I turn this over is there is an implication there. She implies that and Fani was very upset about this, that Nathan Wade is sort of underqualified for the position, has never tried a felony RICO case, has never, so far as she knows, tried any felony case. So again, very unproven. So that's, I think, where we are.
So a couple of things about this that have just struck me as the stories have come out. And the first is that the hourly rate that he is supposedly billing at, which is $250 an hour, is not very high. I don't know what he makes as a private practice attorney, but I would be shocked if it were not substantially higher than that. Is there any indication that the brief is laced with this implication that there's this exorbitant spending, but $250 an hour, it sounds like a lot of money to a lot of people, but for lawyer billing rates, it's not an exorbitant rate by any means. What is the purported basis for saying that this is some outrageous amount of money?
Well, first, it's a criminal case in state court. It's the comparison would not be to, what Manhattan commercial litigators get. What he says is that her salary as DA is around 200,000. So all of all of her ordinary prosecutors are getting a lot less than that. And the allegation is over 3 years, he has billed, I think, around $650,000. And of course, she's getting 200,000 for running the whole office, not just for this case. So it does sound. I mean, you might be right. Maybe it turns out this is he's taking a pay cut, and that could well be an argument. But it is. She sort of has to make the case. We need a special prosecutor, that there's nobody in the office that could do this.
Right. And it needs to be him.
And it needs to be him. And it
looks bad.
Yeah, it looks bad.
Second question. Is there any argument other than assertion that any of the money is kicked back to her? I mean, for example, do we know, is it alleged that when they went to Napa Valley, he was paying for her, or she was not paying her own way? It seems to me much worse if you can credibly allege that, the office paid him a lot of money and he spent that money on her, than it is if you can say the office paid him a lot of money and they did things together.
Yeah, there is zero documentation of that. It definitely implies, money is fungible and they took a vacation together, and that. I believe it does say, it does allege there was something about those tickets to on the cruise lines that he paid for them. I don't know if she's claiming she can tell what account that came from. But, when you're say a Supreme Court justice and you're supposed to have a financial disclosure, you're supposed to disclose what your wife makes too, because...
Wait, who paid for her recreational vehicle?
Who paid for
her recreation, the big shiny RV that she... Oh, sorry, that was Clarence Thomas.
No. Yeah. But it is sort of assumed that certainly if you're a couple, if you're a married couple, you're providing for one another. And if you're a romantic couple, it doesn't look great.
All right. So state of play before we move on. She's going to respond in a formal way February 2nd. The judge is going to hold a hearing February 15th. We will have a lot more clarity at that point. Is that?
That's right. And again, let's emphasize again, hearing myself speak, I want to say, we don't know anything yet. I mean, all of these allegations, they might be false. She hasn't responded. And the second factor is, I'm not Anna Bauer. She knows what she's talking about. I don't read, this isn't my thing.
It's okay. You're doing a fairly good job of impersonating Anna Bauer.
Okay. And I imagine everyone's quite disappointed that I'm taking Anna's place here. Some people are probably despondent that it's just me here. But anyway, this is all we know that's all I know at this point.
All right. Speaking of things that are a little bit outside our jurisdiction, but are close enough in that we're going to sweep them in for purposes of this conversation, E. Jean Carroll, outside our jurisdiction because it's not really a national security matter. That said, it's Trump litigation, it's ongoing, and it would be kind of conspicuous not to mention it at all. So Quinta, what's going on with E. Jean Carroll?
So today and yesterday, we've had proceedings in the second defamation trial brought by Carroll against Trump. So the first defamation trial, listeners may recall, ended up with a finding that in civil court, I should emphasize, that Trump sexually abused Carol, and that he defamed her, and he has put $5 million on bond with the court while the rest of this proceeding plays out. She is now bringing a second case against him because he defamed her. I can't recall whether it was in the middle of or following the previous trial. Again, sorry, Roger is shaking his head.
It was at a CNN town hall,
Okay.
the night of the judgment, I believe.
Oh, no, well,
am I wrong?
I think so. I mean, there might have added a count, but this is when he was president. The odd thing is,
right.
And so this was delayed while they argued various,
okay.
Westfall Act and
that's right. Apologies, yes. I'm getting confused.
This is the second trial,
right.
But they call it Carroll 1 because it was filed first.
Yes, apologies. I'm getting confused because there are too many of them. So there will be a second trial in Carroll 2. I think, if I'm getting my numbering right. But yeah, it's kind of the magical expanding self-perpetuating defamation litigation, because Trump also, during the proceedings yesterday, was posting on Truth Social, or someone was posting from his account, again, calling Carol a liar. So he's now done this again and again and again. There's a variety of cases against him. And what we've seen, I think, in the last 2 days is that his litigation strategy seems to be essentially annoying the judge as much as possible. So this is a case in federal court. And his counsel, Alina Habba, her approach really just seemed to be as abrasive as possible, frankly. And clearly irritating Judge Lewis Kaplan. Trump himself caused a disruption. At one point, Judge Kaplan said he would throw him out of the courtroom if he didn't stop. So it seems like Trump has made the calculation that kind of raising a ruckus is the move here, I assume for PR reasons, since it's certainly not going to help him in court. We also saw, I think it's fair to say, Habba stumbling a bit during trial and sort of tangling with the judge over the procedures for impeaching a witness and putting forward evidence, and all kinds of things that you'd really hope counsel for a former and perhaps future president would have on lock. So I think it's as with the New York civil trial, sort of an example of plenty of shenanigans going on.
All right, we are going to go to audience questions. And I'm going to just do them in the order that they've come in. I'm going to start with Josh, who asks, in Trump's DC case in Chutkan's court, could Trump's team try an insanity defense? They seem to be throwing any and everything at the wall, and his supporters don't seem to care about any of it. I will take a crack at this, which is so at a basic level, they won't do it. He won't let them. I do think some kind of diminished capacity defense wouldn't be the craziest. If you had a compliant client, would not be the most insane, no pun intended, approach. That said, he won't let them do it. And more importantly, the standards for establishing it are really, really high. And he's a sufficiently high functioning human being that like it's not the kind of defense that ever prevails when you use a sort of the insanity species of defense. They tend to work best when you're dealing with uh, either florid delusional systems where you can really say this is somebody who believes that cats are flying through the air and attacking him, or occasionally in situations like Lorena Bobbitt, where you have a very appealing defendant for some reason and a very but they're not situations where somebody brings out a crowd and is functioning at the highest levels of American government. You're not going to be able to establish the degree of disconnection from reality that is not the formal legal standard, which is based on knowing the difference between right and wrong, but is the functional thing that persuades juries in this regard. So that's my answer. Roger, Quinta, what do you think?
I think that's right. There are ways to try to convey to the jury even that, well, he's a quirky guy. He's an eccentric guy. He's this is the way he is. He's charming. It's all out in the open. The Republican Party has bought this. Yeah, he lies a lot. He abuses women. He's probably a criminal. Yeah, but he's charming. And they will try to do that with the jury, but it won't be an insanity defense. He won't permit that.
Yeah, I think that's exactly right. And but I do think if you can convince a juror that there's a soft version of it, which isn't crafted as an insanity defense, it's crafted as he's a quirky guy, but it's that he really believed this stuff. And if it may seem crazy to you. Look, it seems crazy to me, but he really believed it. He honestly believed all this stuff. And so he doesn't really have the criminal intent necessary to convict. That's an argument they're going to make. And it is not formally an insanity defense, which is an affirmative defense you have to prove, but it is kind of like inflected by a diminished capacity argument. And it's based around the same idea, which is that, hey, the criminal intent is an element of the offense. If you can convince people that he's not capable of forming the requisite criminal intent, the glove fits and you have to acquit. All right. Susan asks, Trump's team uses so much stalling and so many opportunities seem available at every juncture to introduce delays. Do you think any ruling by the end of March is possible? Quinta, what do you think? End of March?
I guess I'm not sure what case specifically this is in.
I think she means any case.
I mean, end of March, definitely not. I think the DC, for example, DC trial it was meant to start at the beginning of March, and that is not happening. And it gets pushed back a little farther every day that the DC circuit decides not to rule. So we're definitely in delay land. I think each of the cases are on kind of a different delay. The DC case, I think Judge Chutkan really wants to get moving as quickly as possible once that's handed back to her. In South Florida, it seems like Judge Cannon would be happy to delay as long as possible. So we'll see what the timing looks like.
Keep an eye on New York, because that's a case that has a late March trials date that could go forward if the New York case does not go forward in the beginning of March. And so I don't think you're going to have a ruling or a verdict by the end of March, but you could have something not too long after that. John Bordeaux, lovely to see your name on the chat on the Q&A. The floor is yours, sir.
Delighted to be here. Thank you again for doing all this. This is fantastic. I appreciate you people. You're lovely people. I'll point out to people watching that Quinta's pillow seems to be screaming. I hope that's not an overt message. My question is that Ms. Haba in New York appears to not understand things like rules of evidence or courtroom procedure. Does her defendant have an avenue towards incompetent counsel defense on appeal?
So the ineffective assistance of counsel is a creature of criminal cases, not civil cases. You cannot plead what's called IAC as a way of getting a civil verdict overturned, I don't think. The other thing is that he had other lawyers in this case and he drove them all away. And there's no right to court-appointed counsel in civil matters. And so if you make yourself completely intolerable to your lawyers so that nobody will represent you, you may actually suffer consequences of that in litigation. And the state doesn't have to provide you a competent lawyer like it does in criminal matters.
Your real lips to God's ears. Thank you, sir.
Roger, and I leave anything out on that one?
No, I agree. There is, theoretically you can sue for malpractice. That would be, he would sue her for malpractice. But I don't see how he could do that.
All right.
I mean, if what I haven't seen her performance in court, I'm just
yeah, it has by all Twitter accounts not been stellar.
Okay.
All right. Nathan asks, assuming DOJ may weigh in somehow on the Supreme Court's review of Trump's appeal to the Colorado District and Supreme Court decisions, that it may, after ruling on broader questions, remand the case down to Judge Chutkan's court. That seems improbable, or the appropriate federal district court for Colorado to try the evidence for and against the question perhaps most in dispute. Did Trump engage in the constitutional crime of insurrection against the United States? Okay, so there are a bunch of things in here that I think are incorrect as a matter of assumption. Roger, do you want to take this, or Quinta, do you want to take this, or should I?
I'll try. That wouldn't happen. They aren't going to send this back to a different court. That's not an existing remedy available. I mean, what the Supreme Court does, it can do, but no, it can. There's plenty of variables out there, but that isn't one of them. It will either affirm what the Colorado court did, in which case we can argue about whether it binds anyone else except the Colorado court, or they will overturn it, and depending on the grounds they use, that could end all of this or not. And in fact, there was one brief filed today by Akhil Amar, who is a towering constitutional scholar, but also someone with, it's very difficult to fairly summarize whatever he thinks about anything, because it's very nuanced and balanced and confusing.
Which is not so great for writing briefs.
Yeah. He wrote a very interesting brief, which I haven't finished. And he says, of course, Section 3 applies to presidents. And of course, in effect, it's self-executing. And of course, insurrection can be based on words as well as conduct, or in lieu of conduct. But he sort of implies, even if it upholds what Colorado did, he doesn't seem to think the Supreme Court gets the last word here. It's still a live question for Congress. And anyway, I haven't read the whole thing. Anyway, there's tremendous confusion. We have to wait to see what the Supreme Court says, but it won't send it back down to Chutkin.
All right. Jim Brennan asks, many commentaries regarding the 14th Amendment seem to indicate that a constitutional crisis should be avoided by finding some credible off-ramp for the Supreme Court. It seems to me that we have been in a constitutional crisis since at least January 6th. My question is, wouldn't it be better to confront this crisis sooner rather than later? That is, find that Trump is not qualified now, many months before the election. Trump will claim all types of conspiracy regarding such a finding, but he's going to do the same thing if he loses the election in November 2024 anyway. Quinta, you're our resident expert on constitutional crises. What do you make of this? Is it better to resolve it well in advance so that he has time for the temper tantrum, or is it better to catch him off guard shortly before D-Day?
Yeah, I'm in the resolve it well in advance here. So there's the question of what a constitutional crisis is a really complicated one. I believe I'm drawing on Keith Whittington's work here in dividing between sort of two different kinds. One is a crisis where the Constitution tells you what to do, but nobody does it, or the person in power doesn't do it. And the other is where the Constitution doesn't tell you what to do. And you can imagine either scenario in this instance. I'll actually point to another amicus brief that was filed today by Ned Foley, Rick Hassan, and Ben Ginsberg, all of whom are very highly regarded election law scholars. Ginsberg having for a long time litigated on behalf of the Republican Party in election matters, although he moved away from that recently, essentially saying, like, not weighing in on the merits of what the court should do, but saying that the court needs to address this issue on the merits. Is he disqualified or isn't he? No, cutesy procedural measures. No, oh, there wasn't, due process, so Colorado needs to go back and do it again. None of that. No, just that it really needs to cut to the heart of the matter so that we have an answer. Because you can imagine a kind of nightmare scenario where, let's say, the court kind of hems and haws, we don't get a clear answer on the question. Let's say, just to reach the worst possible world, you somehow end up in a scenario where Trump wins a majority of the Electoral College. You then go to Congress on January 6, 2025, and then Democratic members of Congress say, under the Electoral Count Act and the Electoral Count Reform Act, we think that we have an obligation to prevent this person from serving as president. Our reading of the 14th Amendment is that we have a duty to enforce the fact that this person is disqualified. Then what do you do? I think that that's kind of like the nightmare. It's not a very good situation. I think that is more of a crisis where the Constitution doesn't tell you what to do, where different actors have different understandings of their own constitutional obligations. And you can end up in just a very, very nerve-wracking situation, and one that is deeply uncomfortable for everybody involved. So I am also of the view that the court needs to rip off the Band-Aid and just deal with this one way or the other. I will say that I do think there is going to be a temptation to kind of rule that Trump is not disqualified, because that is the kind of way to deal with this issue once and for all. Because given the decentralized nature of election administration, a ruling that Trump is disqualified would likely have to be hashed out kind of in not exactly state by state, but sort of state by state. There would be a lot of litigation that would follow. And so it's kind of less clean. I still think that they should just do it and be legends. But either way, I think an answer on the merits is really important.
All right, Antti, the floor is yours.
Thank you. So this is a tad frivolous, but what is the current SCIF situation related to the documents case? Do we actually know if Trump and NATO have access to a functional SCIF or not? Thank you.
Well, he certainly has access to one or two, actually, in the Miami area, which is not that close to Mar-a-Lago. We finally found out that he lost the motion to have a SCIF put into Mar-a-Lago or put back into Mar-a-Lago or put very near to Mar-a-Lago. The Judge Cannon hadn't said that expressly, but in a subsequent motion, in a footnote, she admitted that she had ruled against him on that.
All right. Penultimate question from Jeff. Roger, Quinta, I want both of you on this. What is the over-under on $1 billion punitive damages for Trump in the E. Jean Carroll defamation case? Do you take the over or the under?
I don't know enough about the relevant law to have a real sense of this. I would say I don't think he's endearing himself to the jury. So perhaps the damages climbs a little higher every time he has an outburst. I don't know.
A ruling like that, although possible, would be short-lived. I think she's asking for 10 million, and I don't know if she's asking for that as compensatory or punitive, but it's very hard to get more than 3 to 1, and hard to get 2 to 1. Above that, the Supreme Court has said there are due process limits.
Yeah,
assuming New York doesn't have its own cap, which it might.
It's a fun question, but the actual answer is under and well under, because you have a $10 million compensatory damages. There's no way that will legitimately produce more than, say, 30 or 40 million in punitive damages. But by the way, a $30 million punitive damage award, that would be a heck of a thing. So, don't inflate your expectations so high that you don't notice a big deal when it happens. All right, Nathaniel, you get the last question today.
Good morning from Australia, Friday morning in Australia. Thank you all. My question relates to interpreting the eligibility question in Section 3 of the 14th Amendment in light of Congress's power to overturn the disability. I'm imagining a situation where SCOTUS rules that Trump is ineligible around Super Tuesday. He struck quickly from the primary and general election ballots, and in Colorado and other states follow suit or follow that example before Congress has even had an opportunity practically to vote to remove the disability. I mean, the fact that they wouldn't actually in this circumstance is irrelevant to the question, but if that would be the case, to ensure Congress's authority is practically exercisable, mightn't SCOTUS conclude that Trump is eligible to run for president, but not eligible to sit as president, and leave it to Congress after the election to decide on whether or not to lift his disability? Thank you.
So great question. I have a couple thoughts on this. I'm sure, Roger, you do as well. And I suspect Quinta might too. So why don't the two of you go first and I will follow up.
So this has been raised in various ways. Trump raises it pretty directly in his brief. The problem with the problem, couple problems. One is it kicks the can down the road, and you get a constitutional crisis. It just later, if he's elected, and then we don't know. Is he disqualified? Who we still don't know who has the power to decide that. the way this comes up, I think I explained this once earlier. You have situations where somebody wants to be on the ballot and he's not a resident of the state. And so somebody sues to keep him out and says, you have to be a resident to run to be a US senator from the state. And he says, well, I'm not now, but I will be by the time my term begins. And courts have ruled in favor of that and said, yeah, okay, that's true. And so by analogy, you could say, well, maybe both houses of Congress will vote by a 2/3 margin to lift the disability between now and election day, January 20th, 2025. But it's not really realistic. You have a lot more control over whether you move to a state than whether you can convince 2/3 of both houses to lift a disability. And furthermore, everyone in we can take judicial notice. The people in Congress know about these suits going on. They could lift the disability today.
That's the key point.
Yeah.
The premise of the question's wrong, actually. Congress could act right now and relieve whatever disability may exist.
And maybe somebody should introduce a bill to that effect. It would be interesting to see how various people vote. Because to vote for it would be sort of to admit that he, is disqualified. So,
all right, Quinta, do you have thoughts on this?
Yeah, I just say, so there is a textual argument based on the text of the 14th Amendment that it prohibits holding office but not running for office precisely for this reason. And the National Republican Senatorial Committee filed amicus brief, I believe with the Supreme Court or with the Colorado Supreme Court, making exactly this argument. I think it's a little too cute for more or less the reasons that we've set out here, but it is potentially on the table.
Quinta, before we resolve to end today's session, do you want to resolve the question that has been roiling the chat about your pillow?
What is the question?
Is your pillow screaming?
Oh yeah,
or is it sighing with satisfaction?
No, it's a infinite scream pillow.
Yeah, so Infinite Scream is a great Twitter feed from back when I was on Twitter.
It doesn't exist anymore.
Oh no, you could tweet at it, and whatever you tweeted at it, it would shout back, ah! And it was very satisfying. All right, we are going to leave it there. Quinta, Roger, thank you both for joining us. We will be back next week. We will have briefs. We will have probably a DC Circuit ruling, maybe. We will have antics from South Florida and from Georgia. It's going to be a blast. Until then, thank you all for